Good afternoon, everybody. We have now for this session the resource person as Shri Na Vijay Shankarji, who has done many kind of qualifications to his credit, like MSc Physics, CAIIB for banking, CIF Industrial Finance, AIMADM Management, certified PDPCM as auditor for data protection, certified independent director for corporate law. He has a wide experience starting from 1973 onwards in Indian Overseas Bank as officer, manager, assistant chief officer. Then he was a manager in Nagarjuna Group. Then he was manager, general manager as well as resident director in PUTTASWAMY BBDO Advertising. Then he became the managing director in Ujjwala Consultants Private Limited. Then currently from 2018 onwards, currently he is the chairman of Foundation of Data Protection Professionals in India, FDPPI. And he is the founder director, I think so. His functionalities includes banking, faculty in charge, training, teaching of banking law and practice and corporate law. He has authored several books on cyber law, personal data protection, including Cyber Laws for Engineers and Personal Data Protection Act of India, that is PDPA 2020. He is an architect, privacy and data protection certification programs and also personal data protection compliance framework. He is a regular visiting faculty in NALSA, NLS, SUI and several other leading law and engineering colleges. We are proud to have you, sir, and we got your reference to our connections in the cyber security professionals and cyber law. And a very senior being in your experience, we are very much delighted and we feel privileged to welcome you in this refresher course for teacher participants. On behalf of UGC HRDC as well as Department of IT, I welcome you and invite you to take your dice.
Thank you and good afternoon, friends. I understand that this program is going on for more than a week now. I think a lot of discussions have already taken place on cyber law in general. So we hope we will be able to add to whatever you have been discussing and understanding from the perspective of this new topic called data protection. Are you able to view the presentation right now?
Yes,
sir.
Yeah.
Yes, sir.
Yeah, okay. So one of the terms which people normally use in this context is data privacy. So let us first look at the agenda for today's discussion. I understand most of you are actually not non-IT faculty members. That's a very interesting kind of people whom I am addressing today. In fact, I myself came up from physics, and I got into knowing of IT somewhere down the line when I did my MBA, that is that IMRDM first, when I took a project report where I was looking at the management information system in one of the industrial organizations, and there I ended up suggesting something on computerization. Otherwise, as a person who studied electronic computers, I had perhaps discussed at that time something called transistors, cathode ray tubes and other things. We are talking of 1972-73. Okay, these chips and other things came only recently. But ultimately it was the physics people who actually developed internet, as you are aware. And so right now I am into the field of internet and I have never felt that I have not been from the relevant area. So I am sure that most of you also would feel that whatever may be your basic say discipline in which you had your early studies, and perhaps now you are looking at as your profession, certain things related to internet and cyber laws, cyber crimes, and now as we go forward, this data privacy, they will be inherent in all your activities. So let us first look at understanding this concept of privacy, which is somewhat a legalistic topic, and then we go into the concept of data protection, and then briefly we will look at the law related to data protection in India. One of the main objectives of this exercise would be to ensure that all of you have some basic awareness of what is the kind of law which we are coming into. Of course, how relevant is that law to your activity? Perhaps as we go on discussing, if you raise some questions, I will be able to explain more. But that is something which we have to take out of our discussions. Now, when we talk of data privacy, the first thing which comes to our mind is how exactly we define data privacy. Now, does it mean it is protecting the privacy of data? That is, data is an inanimate object. It is actually a representation of binaries, zeros and ones. If you put zeros and ones side by side, you actually call that as a binary document. Now, are we talking of protecting the privacy of data as an inanimate object is one of the questions which you have to ask yourself. Or this word data privacy, is it something similar to what we otherwise know as information security is another question which comes to your mind. Is data privacy an alternative name for information security? The third aspect, which is actually much relevant for us, is to understand that data privacy appears to be something like a human right, and it has been imposed as a burden on technologies. Is that the kind of thing which we are looking at is another question you have to ask, so that you will be able to place this word data privacy in the right context. Now, we use two terminologies. One is data privacy, another is data protection. Information security you are already aware of. Now, and sometimes we use another term related to information security called cyber security. That is, we have any systems and any threats which are coming from outside the system, particularly from the internet, those threats and corresponding defensive mechanisms are looked at as cyber security. When we use the term information security, we are looking at information residing inside a computer device. The word computer, of course, has got its own wide meaning in the sense that a mobile is also a computer. Any other device which processes binary, it is all called computer. So when we use the term computer, it doesn't mean that it is only a laptop or a desktop or something like that. During our student days, computers used to be like big almirahs filling up the whole room. Now we have come to a situation where in my hand I got a mobile which is much more powerful and can do so many things. So law recognizes computer as any device which can process a binary expression. So if you give some instructions to a device in zeros and ones and it can react to that, that is called a computer. Okay, automatically when it produces the results. Of course, normally calculators we don't consider it as a computer. So excluding that, the devices which can store, process, transmit binary information is what we call as computers. So when we look at information security, we look at data which is inside a computer. We want to secure that. That is information security. Basically, what we mean by security of information residing inside a computer is that the information should be available only to the persons to whom it is meant to be made available. That is called confidentiality. Okay. The second concept of information security is what we call as integrity of information. That is, the information should not change without some authorization. So if we have multiple versions of information, then that should be properly authenticated again by the person who is authorized to view the information or operate the information. Any other person making changes, we call that as hacking or unauthorized access to the information and so on. So that is the second aspect of information security. One is confidentiality, that is the information should be made available only to the persons who are authorized to view and operate on the data. Second is integrity, the information should never be changed except under authorization. The third is called availability. Okay, what we mean by availability is if there is some information inside a computer, it is meant to be used by somebody who is authorized to view it. When that person is trying to view it, it should be available. At that time, nobody should prevent him from viewing it. So this is what is called CIA principle, confidentiality, integrity and availability principle, which is part of the information security. But today, when we are talking of data privacy, we are looking at something called privacy protection. What we mean by privacy protection is that we are not actually looking at data. When we look at privacy protection, we look at an individual. An individual has got some concept called privacy, that is, he wants to feel that he is free to interact with people as per his wishes, kind of a thing. That is privacy. Now, that has to be protected. That is the concept of privacy protection, and that is where we try to actually use the terminology called data protection, which is actually personal data protection, which refers to the means by which we provide privacy protection to an individual through protecting some information or data. So that is what we are trying to look at today. So when we use this terminology, please understand that all these terminologies have got specific meanings. So we will be looking at what you have called it as data privacy, which the industry have been using it. People like us try to use the word data protection as a better term to explain what we are trying to do in terms of having this privacy related laws. Now, when we look at this data in any organization or anybody, the total data, we recognize that it consists of two parts. One is called the personal data. That is data with which you can identify a living natural person. That is, you can identify an individual and say this data appears to relate to so and so. It can be your name, it can be your email address, it can even be some kind of a work. Suppose you have a very well renowned, let us say, a scientist, and you have developed certain thesis which is reasonably well known, and by naming that thesis, people know the author of this thesis is so and so. Then even the name of that thesis has an element of identification embedded into it. So when we say identifiable personal information, we don't restrict it to name. It can be any parameter which gives an impression or idea to a recipient of the information that this should belong to this particular person only. So your address, your mobile, and we also say that IP address and that kind of metadata associated with your internet operations, sometimes we call them as identifiers. That is, there are several identifiers, and a couple of identifiers put together, it becomes the identity of the person. Sometimes name alone cannot be fully an identity of a person, because there could be multiple persons with the same name. But when we say that Mr. Ramesh, he is a lecturer in a particular college, then we are adding that second information about his job, and the two together increases the identifiability of the information. When you add a third information, perhaps it will become even more clear. Otherwise, in your same department, there may be two lecturers of physics, both of them may be called Ramesh. Now, in physical world, we are used to adding some initials, father of, son of so and so or something like that. So with each additional parameter, a data acquires the nature of a personally identifiable information. So what we do in this data protection is we identify personal data different from the total data. So whatever is not personal data is what we call as non-personal data. And this information security principles, which I said, CIA principle, it is relevant for protection of this non-personal data. When it comes to protection of personal data, CIA principle is relevant to the extent it is applied on the personal data, but there are a few more aspects which have to be taken into consideration. They are called the privacy protection parameters. So data protection, which is personal data protection, has two elements. One is the information security principle. Second is the privacy protection principle. So in terms of complexity, personal data protection is more complex than mere information security activities related to non-personal data. So if you have so far studied something about information security, remember that when you get into data protection is one level higher than information security, because you have to learn certain new principles. Though you may say that the data sets or the total quantum of data which a data protection person is going to protect is less than what earlier information security people in an organization used to protect, privacy protection or data protection is a new skill which is to be developed. So if you take a college or something like that, you are already using information security. You have got hundreds or thousands of computers, and some of the computers are controlled by the lecturers or authorized of people from the college. Some computers are open to the students, and there may be even possibility that your network is open to the concept of BYOD, that is a student can bring his mobile and then connect, or he can bring his laptop and connect to the network. So your whole cyber space or information space consists of devices which are fully under your control and something which partially is provided to somebody else. In that network, you have got all kinds of information. You have got information about your students, whether they have made fees payment or not, which means that if they have made payment through a credit card, you have that information also. That is, financial information of the students are there, health information of the students are there, his marks which he has got in earlier exams and as well as the current exams after he comes, that also is there. These are all kinds of information which are related to a person. So they are all important information which are personal in nature. In addition to that, you may have subject-wise information which is non-personal information, or the college information may be there, that is also non-personal information. So out of this information, if you look at, let us say, the examination papers or something like that, they become highly, susceptible to attacks, and they should be protected. But they are not personal information, they are corporate information, or in this case, organizational information. So remember that an information can be organizational information or personal information. And as far as security is concerned, it doesn't mean that organization's information has to be secured better than personal information or vice versa. In the case of an individual, if you have got his bank details, that bank information has to be secured as much as any other important information, because if that information is stolen by a hacker, then maybe that student is going to lose money. So therefore, we look at information of a category as personal information and non-personal information, which is not the same way we look at information from this information security area, where we will be looking at security confidentiality in a totally different way. For example, the examination related information is confidential and has to be seen only by the examination committee, whereas a class information about students is visible to all the lecturers who handle that particular class, something like that. So security and access is divided based on the need to know basis, which are different for different kinds of information. The sensitivity of information with reference to personal data is looked at from the point of view of the possibility of any harm which may be caused to the data subject in case the information falls into wrong hands. So the personal data, we use a terminology called sensitive personal data, whereas in the case of non-personal data, we only sometimes look at data from the perspective of confidential, secret, or something like that, or open. Okay, so in non-personal data you've got open information, so that anybody who wants to know about the college, they have the website and information about that. But there will be some information which will be available only to certain category of people, then that will be allowed access only to one class of people. That kind of segregation we do for information which is non-personal. But when it comes to personal data, we segregate the personal data into sensitive and non-sensitive, and then we try to apply whatever law which we are going to discuss now to that personal data. This classification of data into personal and non-personal is the very first step in going for what we call as data protection. So the other three nomenclatures which you must become familiar is, in the case of information security, whatever processes you are using to secure, we call that as ISMS, that is Information Security Management System. In terms of privacy, certain people use the terminology Personal Information Management System. So PIMS. PIMS includes the management of security plus privacy, whereas ISMS includes only information security. But we now try to use another terminology called PDPCMS. What we mean by PDPCMS is Personal Data Protection Compliance Management System. The reason is the law requires every holder of personal data to be compliant to certain rules and regulations, and if they don't comply with that data, there are adverse consequences. So every organization will have to put in place something called a personal data protection compliance management system. So we look at PDP-CMS system as the goal of information security in terms of data protection. So that is some terminological references which we have to keep in the back of our mind.
Sir, sorry to disturb you.
Yeah.
Sir, can you again explain what is PDP CMS and how it is different from PIMS?
Okay. May I know who is speaking?
Sir, this is Dr. Samrat.
Yeah. Now, PIMS is Personal Information Management System. Okay, that is the terminology used internationally for a system which tries to protect personal data from the concepts of the confidentiality, integrity, availability, and privacy protection. The privacy protection will have a few parameters which I will explain later on, like whether you have got the consent from the person or something like that. I will explain that separately. Now these two together, it's called PIMS. Now PDP CMS, we are recognizing that ultimately I am trying to comply with a given law. Say it is I can make a statement that I am trying to protect privacy of individuals, but none of the IT people can really protect the privacy of individuals. What they can do is they can do something with the information, and what is that they can do with information? Law has asked you to do something, and we try to focus on that. So personal data protection as given in the law, which we have to comply. When I focus on that, I call that as PDP CMS. So PDP CMS includes the PIMS system or ISMS system, but here the focus is entirely on the compliance to the law. I will also explain why I am having this focus instead of taking a lofty ideal that, okay, I will protect privacy of all my students or something like that. It is not possible, okay, because the concept of privacy is so complex that we don't even know what is the privacy of people. For example, now all of you have come to this program, your photographs are visible. Now, how can I understand that one person here would not mind his photo being recorded, another person would not like his photo to be recorded. Now, if the organization is looking at meeting the privacy requirements, they should ask one person, do you want your photograph to be recorded? Another person, you don't want to be recorded, and then keep track of that 30 people having 30 different you can say choices, which is not feasible. So what we then do is, let us see what the law has done. Law is a common denominator, okay? It has done something, okay? So when I have sent you the invitations for this conference, I will put a footnote and ask a consent that this particular session is being recorded. Now I am giving you that notice, therefore you are presumed to know that you are giving a consent for the recording. So now that is, from compliance point of view, 100% acceptable. Okay, now I am not taking on the stand that I am protecting privacy, but I am only trying to say that I am protecting the compliance requirement as given in the law. So I am trying to bring that focus. I am trying to rename this system into PDP CMS. We have used this PDP CMS for our certification programs in FDPPI, Foundation of Data Protection Professionals. We give a certificate that is called Certified PDP CMS Auditor, kind of a thing. So we feel that that is a better expression of what we are trying to do. Okay.
Sir, what I have understood, just one thing, sorry to interrupt. Personal data is individual wise, right? Whereas non-personal data can be individual, it can be organizational, it can be corporate, anything with a different category of access, right? Whereas personal is only individual wise, individual.
Total data may include personal data and non-personal data. The moment you recognize something as personal data, what is left out of total data, the residual thing is non-personal data. So non-personal data doesn't include personal data, because there is going to be separate laws. Say there will be a separate law for personal data protection, separate law for non-personal data protection. Okay. Now, before you make this classification, what you have is total data, which is a mix of both. Okay. You please wait for some more slides, then I will explain this concept of privacy, and then we will have another question and answer session with more details. Okay.
Okay.
Okay. Now, before we get into the data protection, let us quickly go through how the privacy law has emerged in India from the Constitution, Article 21, to a law called Information Technology Act 2000, which you have studied already in depth, which was amended and became a version in 2008, which sometimes people like us call it as ITA 2008, which is not the name of the act, but that is a recognition that ITA 2008 version is totally different from ITA 2000, so we sometimes use that. Then now we are having a bill called Personal Data Protection Bill 2019, which is in the Parliament, which is the one which is likely to be the law called Personal Data Protection Act. This is how the privacy law has come, and let us see this journey of privacy law, because when we are studying privacy, the PDPB, we must always remember that PDPB exists because of the history. We call it as legislative history, and to that extent this transition of how privacy became important in India is useful. For example, this Article 21 of the Constitution, which you can call as the most fundamental law of the land, from which actually other statutory laws will emerge out. Article 21 says there is a right called protection of life and personal liberty of all the citizens, and it simply says no person shall be deprived of his life or personal liberty except according to procedure established by law. This is what Article 21 says. At various points of time, the Supreme Court of India has given out some judgments which we sometimes call as precedences, okay, and call it as more or less the operative law. And at various points of time, it has held that the Article 21 does not say privacy. The word privacy is not used there, but it says life and personal liberty. And what the Supreme Court has held in various cases is there is no life unless it is dignified. So therefore, dignified life is part of this Article 21. And to be a dignified life, this right of privacy should be there. What is the use of somebody not having the fundamental human rights or democratic rights such as freedom of speech or the privacy? So without that, we say life is not dignified. So law should recognize that life as mentioned in Article 21 should apply to dignified life. That is how privacy is brought into this. Similarly, whenever we say liberty, we use the term liberty in the context that it should be freedom which the person feels. Okay, liberty or freedom is not something externally given, it is something which the person feels. So generally, courts have held that privacy is something like a right to be left alone. A person should feel that if I have privacy, it means that I am left alone from unwanted interference. So that is how the courts have been interpreting this Article 21 for a long time, since the olden days. But today, on 24th August 2017, there was a very important judgment from the Supreme Court, which we refer to as PUTTASWAMY judgment. K.S. PUTTASWAMY himself is a judge, but he was a petitioner in this particular case. He is not one of the 9 judges which you see. Justice Keher was the Chief Justice, and he was the head of the bench. And this particular judgment has defined the fundamental principles of privacy. What it said simply was that privacy is a fundamental right under our Constitution within the parameter of Article 21, and it is subject to reasonable restrictions which are mentioned in another article called 19 subsection 2. So the concept that right to privacy is a fundamental right subject to reasonable restrictions was made out in this PUTTASWAMY judgment, and that has become the guiding principle for us in the coming era. Now, privacy being a fundamental right, what it means is that the government cannot infringe this right, because constitution protection is government's duty. So there has to be only a due process of law if anything has to be infringed. And therefore, whenever a government comes out with any law, it is subject to a scrutiny from the judiciary saying, are you infringing any constitutional right? So that is the implication of something being held as a fundamental right. However, though normally fundamental right is expected to be held against the government, there was a Kerala case which is called Umanchandi case, in which the Kerala High Court made a very important observation. What it said was, this was just after the Supreme Court judgment of PUTTASWAMY judgment, it said the newly recognized fundamental right of privacy, which takes in its fold something called reputation protection, would merit classification as a fundamental right that protects an individual not only against the state but also against the private citizen, which means that being a fundamental right, normally we say it is the responsibility of the government to protect the fundamental right. But Kerala High Court said every private company, every private citizen is also equally responsible to protect the fundamental right of another person. Otherwise, you may be considered as infringing the fundamental right. So, if the college is infringing on the fundamental right of a student, college is also responsible, even though college is not the government. That is the implication of this Kerala High Court judgment. But remember that any infringement is subject to reasonable restrictions. So law can impose reasonable restrictions. But what we have in the Constitution is that reasonable restrictions can be imposed in the interest of the sovereignty, integrity of India, friendly relations with foreign states, public order, and like that. All these are incorporated in our data protection law. So right to privacy is not absolute. It is subject to certain restrictions. So therefore, whenever somebody accuses us that you are infringing on privacy, immediately we have to go back and check our reference. Does it come under any of the exceptions? So, for example, if you are managing the students, some information of the student has to be managed because otherwise you cannot run the college. So therefore, in the corporate scenario, we have similarly in the employment scenario, we will be observing the employees. Now privacy laws sometimes question, have you taken the consent from the employee for that, this, like that. So we have to be aware of exceptions and other aspects of the privacy law, and remember that the privacy right is not absolute. Okay. Now, from the government side, since being a fundamental right, it imposed a duty, the government set up a committee called Justice Sri Krishna Committee, which came up with a first recommendation of what was called PDPA 2018. This was revised and it has been made into 2019 version, which has also been examined by 30 parliamentarians in a joint parliamentary committee, and this is due for being processed into an act anytime. We hope it will happen in the next monsoon session. So this is what PUTTASWAMY judgment said. But one important thing this PUTTASWAMY judgment did not clarify is, it said all of you should consider privacy as a fundamental right, so protect it. Fine. But court did not actually give an exact definition of right to privacy. So we are all left wondering, what is that I am going to protect? Now in that, we have actually driven certain interpretations from out of the various judgment, and even this PUTTASWAMY judgment, which had 9 different views, Justice Chandrachud actually gave a little more clarity and said right to privacy is right to be left alone, and therefore that is what you are supposed to protect. Earlier to this, there have been instances where courts have told about protection of physical privacy, like they were telling that police should not go and knock at the doors of a person in the night, that because that is his right of privacy, something like that. This was there in Karak Singh's case. There's case is called Karak Singh. Those of you who are interested in law can check that. Similarly, in Rajagopalan case, the right of the press to infringe on the privacy of an individual, how much of information can be made public, was discussed. These were all present. Now we are trying to redefine this whole thing called left alone. Now what we have now arrived at is, a person may feel that he is private today, not of course his preferences for privacy may change from time to time, and different people may have different privacy preferences. So to make a law to say that for all the 130 crores in India, I am going to make a law called privacy is obviously not possible. So it is a state of mind, actually. Being left alone is a state of mind. So even if I am in the crowded local, I may not have any problem about privacy. But sometimes even if 2 people are standing in front of me and staring at me, I may feel that my privacy is perhaps infringed. So it is not a question of how many persons are looking at me or near me, but something else which is inside a person's mind, which is difficult to capture. So since it is not possible to capture the state of mind and give a law, what the law has done is, we will give an individual a choice to express how his personal information can be used. By giving him a choice, and anybody else respecting that choice, we are trying to give the privacy protection. So privacy protection ultimately boils down to the right of an individual to decide how his personal information may be used by others. So this is the definition of right to privacy, but this comes with the inherent conflicts, like one person's privacy conflicts with another person's right to information, one person's privacy conflicts with another person's right to security. Because of these things, making a legislation for this, we need to manage these various conflicts. So that is why it is very difficult to make a law for privacy, which we are trying to do. So now this privacy protection, which is a human right, is now felt as a responsibility of the industry, because personal information is data, and data is used as an essential input for decision making. And in many businesses, data is the raw material. When we say raw material, data itself is processed into a higher value added information. So that is one of the reasons why data is an important asset of a particular organization, and that needs to be protected. Now, in the last perhaps 1 week, you have discussed why cyber law awareness is important for IT industry or education industry, which prepares the IT professionals. Because if our students do not know what is a cyber crime, but we teach them how to develop a software, they will be using that skill to develop a malware instead of a functional software. So there is a need for people to be aware. This is what you might have seen, so I will not go into that. But now we will say data protection law awareness is also important, because data protection is a compliance law. What it says is, the law says that every organization which processes personal data should do A, B, C, D, E. If you don't do this, I will impose certain fines on you. In cybercrime law, like Information Technology Act, it also says do's and don'ts. And if anybody infringes on that, we call that as a cybercrime. We either put a civil liability or a criminal liability, put a person in jail. But that happens only when a loss has occurred. In data protection law, occurrence of a loss is not a condition precedent to apply this penalty. And the penalties are not small. Penalties can be up to 4% of the turnover of an organization. You imagine the turnover, and that too, if it's a multinational, the total worldwide turnover is taken, and 4% of that is the maximum fine. And such fine can be applied even when nobody has suffered a loss. Like, there is a compliance requirement, let us say that you must appoint a person called a data protection officer. Okay, that's a compliance requirement. You have not appointed a data protection officer. Because of that, nobody has suffered a loss as of now. Okay, but that is a non-compliance, and you may be put into the penalty. There are laws related to use of CCTVs, for example. Now, if in your college you have got CCTVs everywhere, now, if there is a question, have you taken the consent of people? If you have not taken the consent, whether or not anybody has suffered a loss is immaterial. Non-compliance of not taking the consent becomes the point under which penalty can be applied. So this is the major difference between a cybercrime law like NITA 2000 and a compliance law like this data protection law. And because if penalties are huge, there would be liabilities for the organizations in which our students are going to work tomorrow, and therefore to protect their career, they need to know about data protection law. Plus, of course, this development of this law itself is opening up new careers. So another thing which we in the student community should remember is that the power of technology in the hands of this immature youth is a dangerous weapon, and they may not know the limits to which they should use this power, and for them it's all play. Okay, so non-compliance may become part of their normal routine, which is why we have to build a sort of ethical kind of a culture at the earliest stage. There are a couple of questions. I will just try to take that. Something about I'm using the terminology students because you are all college lecturers. Otherwise, in a company, it becomes a company, employees, and maybe customers. Okay. I'm trying to draw a similarity with you. All your students have the right to privacy. All their parents who come to your office, college premises have a right to privacy. Your own employees have got a right to privacy. Now the management has to ensure that in managing this right to privacy of these people, you don't transgress the law. Otherwise, you may be liable for the penalty. There is no exemption for educational institutions. There have been some countries where some exemptions have been given to private educational institutions or some non-profit kind of a person. I will come to that how to take a consent later on. Okay. Now CCTV, if you are having, there is a owner of the CCTV footage, which is your principal or the administrative person, and he is responsible for most of the thing. If you have outsourced the CCTV management, then that outsourced manager becomes your contractual person who is called a processor, but any non-compliance by that processor is also your responsibility. Okay. So as an administration, the person in charge of the CCTV feed will be responsible for protecting the privacy. Now, if let us say, if I am in a college which have got 10 different departments, I may make the head of department of each of the department the owner of the CCTV footage coming from all the classes of his department, because the head of the department is the one who is perhaps looking at other lecturers, whether they are teaching properly, whether students are doing properly. So the CCTV feed goes to the head of the department. So he becomes sort of a sub-controller for this. So the responsibility from the top, I use the term principal, maybe an administrative person or whoever is that, or the board. From there, they may distribute the responsibility to different kinds of people. In fact, that is something which they ought to do, is what I am trying to say. Okay, we'll address this consent questions again a few minutes later. Okay, so now we will be looking at a little more detail on this Personal Data Protection Bill 2019, which is likely to become a law. Remember that even though this is a bill yet to become a law, one thing you must remember is that presently we have got Information Technology Act, which has got a section called Section 43 capital A. I don't know whether you discussed it in detail. You would not have, because you are focused more on cyber crimes. 43A of Information Technology Act is now transforming into PDPB 2019, in the sense that once this becomes operative, this 43A will be removed from IT Act. So there is a direct legislative declaration that what we are doing in PDPB 2019 is a replacement of one section called 43A. Now, subsequently, there will be regulations and notifications which will be coming from an authority called Data Protection Authority. And from there, this act, what we are having now, we are having only bill. It may undergo some minor changes before it becomes an act. That, along with the notifications, will become the future regulations which we have to keep track of. Okay, but ultimately the Personal Data Protection Bill will coexist with the Information Technology Act. It will also perhaps coexist with another law which is likely to come in a couple of years, for which some work is going on, that is called Non-Personal Data Governance Act. See, we are protecting the personal data but governing the non-personal data. What we are meaning by that is, this Non-Personal Data Governance Act will tell how an organization can make money out of non-personal data, like creating a data package and selling it to somebody else, like that. Now, protection is there in PDPA for personal data, and ITA 2000 looks at protection of personal data and non-personal data. So Non-Governance Act looks at making money out of the non-personal data, whereas protection of non-personal data is there in the ITA 2000 itself. Protection of personal data will be looked at in the PDPA. Okay, fine. So some discussions are going on. Okay, fine. We'll come back to any questions later on. So PDPP will perhaps coexist with other laws, which means you cannot forget ITA 2000. Okay. Now the difference I already told you, ITA 2000 is applicable when there is what we call as a cause of action. Somebody has suffered a loss, he goes either to the police or go to a person called adjudicator for claiming financial damage, or he goes to the police to file a criminal complaint. Without that, ITA 2000 remains inoperative unless, of course, the law provides that the court, for example, it can suo moto recognize an offense and take it, but very few of the courts will do that. So ITA 2000 normally gets invoked when a victim actually tries to invoke it, whereas PDPA doesn't require any victim. The simple non-compliance aspects of not appointing a DPO or not conducting what we call as a audit, the data protection impact assessment. Now, as soon as the PDPA comes, remember every one of the educational institutions will have to conduct a DPIA, record it, document it, submit it to the Data Protection Authority. Probably none of you will do it for some time, but that itself is sufficient to impose a penalty. So that is the nature of this Personal Data Protection Act, which is compliance oriented, does not wait for something to go wrong for imposing the penalty. And because 43A is being replaced by information technology by the PDPA, and Information Technology Act has a concept called due diligence, we say that PDPA, though it is presently a bill, should be considered as automatically operative even today. So it is not a question of waiting for the act to be passed. Even today, 43A talks of something called reasonable security practices. It applies, of course, to sensitive personal information, and therefore 43A is applicable, and there is something called due diligence, and PDPB is the due diligence. Mr. Anshul Gupta has got some question. Mr. Gupta?
Yes, sir. Actually, that question I have already asked to one of the previous speaker, but since I'm not satisfied, so I'm asking.
Yeah.
So according to ITA 2000/8, it is said that this law is applicable for the Indian and foreign all violators of data branch. But the issue is somewhere it was written that the machines should be located in India. So this ambiguity is not clear to me. Still, it is there.
No, that is, if a provision of Information Technology Act is, let us say, not followed through, that is what we call as an offense. Okay, so an offense has been committed. Now, for punishing an offender, okay, you have to find out who is the offender. Now, the person may be a citizen of India, might have committed the offense sitting in India or sitting elsewhere. What this law says is it has got what we call as extraterritorial jurisdiction. That is, as long as there is an effect, adverse effect of his action in India, which is recognized as if one computer in India has been used in the commission of crime. Okay, there's a network of computers, an internet packet travels 200 hops before it lands up in India. But if one computer in India is used in the commission of the offense, which could be the victim's computer himself. So if you are in India, if you are offended, let us say you get an offensive, let's say photograph, say some obscene photograph. Now, it is in your computer that this obscene photo exists. So your computer has been used, even though it has come from abroad. So the law says that as long as one computer in India has been used in the commission of crime, then that comes under section 67 or 67A or whatever is the Act of Information Technology Act. Now the person may not be in India. Now the law recognizes that person who is a foreign citizen as an offender. Now can you go and catch him? Now that is a jurisdiction which is going into law enforcement. See, legal jurisdiction exists for offenses committed by persons outside India. Okay, but police jurisdiction may not always be that easy. Okay, but that is a different. Then you have got a treaty, like now we are working on this Nirav Modi's case or Vijay Mallya case. They are offenders in Indian law, but my police cannot go there and just catch him and bring it because there is a law enforcement jurisdiction. So that is different. The law has got extraterritorial jurisdiction. Implementation has to be through other kinds of means. I can give you one or two examples. I don't know, this is actually a cyber crime issue. There was something called a Dmitry Sklearov case. If you have seen, Dmitry Sklearov was a software developer, a team leader working in USSR. He developed a software which was being available for download in USA. Okay. Now, this software was supposed to be infringing a copyright law of USA. I'm not going to the full details. So, the US company, which was actually Adobe, wanted to take action against Dmitry Sklearov. Okay, legally he has offended, but how can my police go from USA to Russia? What they did, they conducted a seminar in USA, invited this person as a guest speaker. Okay, so he came and he was in the physical soil of USA, so he was arrested and tried and so on. So physical jurisdiction is different. Okay, Data Protection Act also has got this extraterritorial jurisdiction. Like a company which is abroad, which is processing personal information of Indians, is liable for under this act. This is same in other countries also have similar thing. It is not like it is new. Every country wants to say, for example, if somebody sits in Pakistan and sends a missile which lands in Bombay, should we punish it or not? The person is punishable. So if he sends a drone from there, so if the effect is in our soil or our citizens, normally laws will say that I have got a right of calling the other person a offender. But whether I can go and take action, that is a different issue. If it is a friendly country, I may go and take the assistance and get that person. If it is an unfriendly country, if it is China, I may not be able to do that. So law defines jurisdiction of applicability, and it translates into other forms like enforcement jurisdiction, which is different. Judicial jurisdiction is different. Okay. Yeah. So 43A already has got reasonable security practices, which actually is a way of telling that every company processing personal data needs to follow some guidelines. If you don't follow the guidelines, you may have to pay damages. That is what section 43A says. It is applicable to body corporates, but the word body corporate includes partnership and other things. It may not include non-profit organizations. That is the current Information Technology Act. In the Data Protection Act, everybody will come under that. But if by not following reasonable security practice, if a wrongful loss is caused, then the company will be liable to pay the damages, is what section 43A says. And reasonable security practice is defined. I will not go into this in detail, but there is a definition of reasonable security practice which incorporates what is called due diligence. This word due diligence is also used in the section called section 72A, which talks of 3 years imprisonment. 43A talks of financial penalty. 72A talks of the criminal liability. There is also a section called section 79, which is applicable to intermediaries. In all these sections, there is a concept of due diligence. What is this due diligence? This is what we are now asking the Twitter to do. That is, you have to have something called a privacy policy. You should have a collection principle. These are all due diligence. If this due diligence is not followed, then that is something which is punishable. Okay, this is what Information Technology Act says. There are other sections, 67C, 65. This is the reason why I say that PDPB will coexist with these things. Very recently, you have come across on intermediary guidelines also. So it expands on the requirement. So we have today a robust data privacy law in the name of Information Technology Act, and we are only supplementing it with this new act. Therefore, all persons should consider that Data Protection Act should be taken note of today. In fact, already 3 high courts in recent days, Odisha, Delhi and Madras, have started quoting from the bill, Personal Data Protection Bill, and say class so and so of the bill says there is something called a right to forget. So I am going to give in my judgment that this person has got a right to forget. When the courts start recognizing the bill, you know that this due diligence aspect is something which has been established as present. Why I am saying all this elaborately is that there is a tendency in the market today. Some people say, let the act come, then I will take some action. This is a wrong way of doing it. Compliance has to be done before something is brought in. If from tomorrow law comes, I will not be compliant on day one. Even if the government gives me 6 months, 1 year time, which we are expecting, still that time is required for compliance. So better we think of taking action today, which means that all the colleges should start asking tomorrow their principal, do we have a data protection policy? Okay, anyway, that is something for you to do after you go back to the college. Now, I will briefly explain what is there in this data protection law. First is every data protection law, what it does is, first of all, it says where this law is applicable. So applicability has to be there. Second is, it says how you have to capture the choice of the individual. We said privacy is a state of mind, and you have to capture what the person wants and then try to protect the data according to his wishes. So how to capture that? The word consent comes here. That is called the legal basis. Then how to implement this choice? So there is a set of compliance requirements. So if you don't follow this compliance, you are liable for the penalties. There is also, of course, a oversight mechanism, a regulatory authority. So these are common things in every privacy law, which is also there in our law. If you look at our law, see, it has got 14 chapters, totally 98 sections. Just to give a bird's eye view, there is initially the preliminary definitions and applicability, then exemptions, then there is something called obligations, something called rights of data principle, then how to handle the children's data, this obligations includes consent. So there is a separate chapter on where consent is not required. So this is one set of requirements in 4 chapters. Then there is something called compliance, which is accountability measures. There is also something you must have heard of this, restrictions and transfer of personal data from one country to another country. It is called cross-border transfer, or in other words, it is about data localization. So there are a couple of sections on the regulations like that. Then there is an authority which is being created called Data Protection Authority, an adjudication authority, an appellate tribunal authority. Some miscellaneous aspects are covered about how finance will be raised for this authority and how it will be disposed of. And then, of course, penalty and compensation. So this is the bird's eye view of the structure of PDPB. It's just to give you an idea of what are all the things covered here. But we will look at only the very essential features. For example, the applicability. Where is this Personal Data Protection Act applicable? First of all, it is applicable to all types of entities. It is applicable to government entities. It is applicable to private commercial entities. It is also applicable to non-commercial entities. No exemptions for educational institutions. Okay. It is applicable to personal data processing, which is collected, disclosed, or shared in India. It does not apply to non-personal data. It does not apply to the anonymized data. Whatever data does not have any record of personal identification. Okay, so for personal data collected and processed in India by any type of organization, this law is applicable. Now, as far as the organization is concerned, it can be government company, it can be company, whichever is incorporated in India. And some of these companies incorporated in India may have establishments outside India and may be processing the personal information of non-Indians. So they do come under this law to some extent, and they have, of course, certain possibilities of getting an exemption by notification. Similarly, if entities are established outside India, but they are looking at India for business or for looking at the profile of Indian citizens, they will also be coming under the applicability. So Indian companies definitely come under the law. Foreign companies will also come under the law if they are looking at Indian processing. But the applicability is restricted to personal data, which is collected and processed in India. So this is basically the applicability. Now, educational institutions will also be considered as what we call as data fiduciaries. The law recognizes somebody called data fiduciaries, that is those people who are responsible for the processing of the data, that is those who collect the information and decide how the information has to be processed. They are called data fiduciaries. Those who process it under a contract with the data fiduciaries are called data processors. The responsibility for compliance lies with data fiduciaries. Now, every college is a data fiduciary. Okay, individual societies, trusts, whatever may be the form, they will come under this act. Some of these data fiduciaries will be called significant data fiduciaries based on the volume of data they process, the volume of even the turnover of the company. Based on that, they will have a classification called significant data fiduciaries, and several compliance requirements are there for significant data fiduciaries. Now, just as Information Technology Act wanted a compliance officer to be appointed, and some of the companies use the terminology called the Chief Information Security Officer, CISO, significant data fiduciaries are mandated to appoint somebody called a data protection officer. They are mandated to do annual data audit. So there are several things which are mandatory for significant data fiduciaries. And any organization, for example, if you take a college with a 10 years existence, you have not only the 1,000 students of the current year, the last 10 years students data is also with you. So you become actually a huge entity holding the information. So you may become a significant data fiduciary. Remember that data which is active is one category, data which is archived is a different category. So your information processing has to take into account various things like, okay, previous students 2 years and below, I will archive them in a separate server. I will not put it in the main server. So something like that, but you may still need it. You cannot delete old data because somebody may ask for some result or something like that, how much marks the person has got in background verification. So I don't think you can destroy the students' data for several years to come. So therefore, your personal data protection obligation keeps on accumulating year by year. It will never reduce, it will only increase. And if your organization is 50 years old, 100 years old, remember that you have got a huge liability on hand. You will become a significant data fiduciary. Normally, this is a civil liability which this act talks of. There is only one particular provision which is called re-identification of a de-identified information, which is a criminal offense having 3 years imprisonment. So that is applicable to the organization, and vicarious liability is also there for the head of the institution and maybe the divisional heads. In the ITA 2000 section 85, you have heard of the term that a person who is in charge of business is liable. So similar thing is there in PDPA also. It has even made a specific mention that in government departments, the head of the government, a particular department, will be considered like a CEO in terms of liability. So don't expect private sector educational institutions to be exempted. There will be liability under this particular act. So therefore, compliance is a necessity, not just a choice or a good practice. So we have to start doing something immediately. Quickly going through other provisions, there are exemptions. One exemption is for government agencies, law enforcement agencies, data processors who work under the contract of somebody else. For research, de-identified information can be used. Small entities, it is there, but it is not very useful because manual processing alone is exempt, not automated processing. Today, we don't have many small entities processing manually. Everybody uses computer. Then there is something called sandbox, which is important. That is where there is a need for you to have some testing of an innovative project. If you feel this act is going to hinder my experiments, you can get a notification for a sandbox environment under the DPA's oversight, and within the sandbox environment, you can execute your project. Normally, sandbox permission will be given for 1 year at a time for 3 years. So 3 years, any organization can opt to do certain technology related experiments in a sandbox environment without getting some exemptions under the privacy law. Otherwise, people may say, if you bring all these conditions, then how should I function when a new product has to be developed or something like that? Okay. Now, obligations and rights, there is lawful processing. Purpose limitation means that you should collect the information and process it only for a particular purpose. You should collect only as much as is required. You have to give a notice to the person before collecting. Ensure that data is accurate, that is called quality of data. Retain the data only as long as it is required, and the organization will be accountable for compliance, and consent is a necessity. So these are the obligations which the act says, and it also gives a right to the data subject. We call him as a data principal here. It says that he can at any time have the right to confirmation and access. That is, he can check whether my data is being processed with you. You have to tell him yes or no and give him the details. Right to correction if he says your information is incorrect. And it also has got something called right to data portability, taking away the personal data to another place or returning back to him. There is something called right to be forgotten, which is exercisable only with some quasi-judicial permission, not otherwise. Okay, so these are obligations and the rights. I will go through this consent. Now, consent is before you collect the information, you ask the person, I want your information, this kind of information for this particular purpose. Do you agree? He has to give the consent. That consent has to be called free consent as per our Contract Act. It should be informed consent because you have to make him realize why you are collecting it, what you are doing with it. It should be specific to the purpose and it should be expressed in clear terms, and it should also be capable of being withdrawn. So this is the important aspect of Indian law. It is not in GDPR and other things, consent is not that mandatory as we have seen in India, but here consent is absolutely essential. You can take this consent from the students when they apply for the application. You may have to actually get a consent not only from the students but also perhaps their parents, because if you are processing many times the data of the parents also, so you will have to look at where to get this consent. CCTV and other things, you can put up some notices because they are dynamic at the point of time, but processing of the students' information you have to take at the time of the application. Maybe it has to be renewed from time to time, at least every year. When a person goes to the next listing, please get another consent form signed. Okay, excuse for consent, as I told you, for functions of state, medical emergencies. So some concessions are there. Similarly, some concessions are also given for employment. Don't think that the act is so rigid that you cannot do what you normally will do. We call most of these things as legitimate interest. The organization has a legitimate interest and that is protected. Only thing is you have to have proper documentation. So there are several reasonable purposes. In the case of employees, we say making a evaluation is there. You also do an evaluation. This evaluating a student is called profiling. So profiling is permitted, but you should have a proper documentation. Okay. Now, wherever the personal information of a minor is involved, that organization will be called a guardian data fiduciary. I hope high schools and others will come under that. Maybe you may not be coming under that. So significant data fiduciary will depend on many of these things. If your organization comes as a significant data fiduciary, you will have to register yourself with the Data Protection Authority. You have to conduct what is called a data protection impact assessment, keep some records, have annual data audit, designate somebody as a data protection officer. These are all the obligations which will come to you if you are a significant data fiduciary. So there are various accountability requirements. This is what we call as compliance, which a data protection officer has to do. Every organization needs to appoint a data protection officer. Maybe one of you can be designated or an exclusive person has to be designated. And that person will have to prepare, first of all, a statement called Privacy by Design policy, submit it to the Data Protection Authority, get it certified, and it may be published also. So this is like what I call as prospectus in the financial terms. So a big document requires to be prepared. Now, data protection officer is a person which has got multiple roles to play, including monitoring of the activities within the organization, dealing with the external data protection authority, meeting the grievances of the data principals, then giving advice to various departments. So it's a huge responsibility for data protection officer, which every one of the data fiduciaries need to have. There is not much of a restriction in the new bill regarding transfer of data. Most of the data can be transferred subject to certain conditions. But if there is any data breach, it needs to be notified to the authority. Exact details of how quickly it has to be done will be given later. But DPIA, what it means is that you need to prepare a statement that if you are undertaking a process, these are the risks and how you meet the risk. That has to be captured as a report, and sometimes it may have to be submitted to the authority also. Okay. So now penalties, as I told you, it is 4% maximum. Criminal punishments are there in only one case, which is actually for re-identification of de-identified information, can be made applicable to the executives. Data processor is the external person. Now, having said this, professional organizations like us are working on developing a framework for compliance, which is what we call as a Personal Data Protection Standard of India. Those of you who are interested can look at our site called fdppa.in. You will get the details, but we are looking at creating a framework under which personal data protection compliance to PDPA becomes somewhat systemized through this. In fact, FDPPA is also doing something which may be of interest to you. We are trying to bring privacy knowledge to the student community. We are trying to encourage colleges to set up student chapters. We call that as Privacy and Youth Program. Probably if any of your colleges are interested, you should look at this so that we can have a series of programs addressed to the students. We are presently doing it for law colleges also. In one of the things we are trying to help the college to do a moot court competition. Some of you might have heard of it. In the technology scenario, for example, we can run a campaign for development of some privacy related software development, some hackathon kind of a thing. A lot of things are possible. Think of such possibility. And with this, I will close it, and I have left 10 minutes for more questions. I have no problem if you want to extend, but depending upon your schedule. We'll have 10 minutes of questions and answers. Okay. Anshul Gupta.
Sir, very small question. You already, I mean, clearly distinguished, beautifully distinguished between personal data and private data. So I'm taking it in my college sense. For example, a group of researchers are working on some socio-economic condition for which they require the name of the candidate, his parents, his economic background, and the geographical location where they are coming from, etc., etc. So unless they assign these quantum numbers to students, it is not, I mean, personal data, of course. When they assign these quantum numbers, it is personal data, but they require it. So they intimate their DPO, would be DPO or CISO, to get a sandbox. So which is the authority and what is the mechanism to get it?
No, if your department is doing this processing, okay, your organization is a data fiduciary. Within that data fiduciary, one of you is a internally, I call them as an internal data controller. Ensure that you take a purpose specific consent. That is, you take consent for, it's like in medical these things, if you are doing a testing, let us say COVID, say vaccine testing, that group you take a specific consent, is it not? That this is still in test, I'm agreeable to, for me to be tested like that. So like that, you have to take a purpose specific consent, and then you can collect whatever information which is required for your research. That is, you don't collect information which is not required. See, suppose you can do it without, let us say, the name of a person. Say most of the research we need perhaps gender, age kind of a thing. I don't need to know the name. Then you use de-identification or pseudonymization. That will reduce the risk of compromise. Okay. So with that, you collect whatever information is required. There is no bar. But if your department is collecting it, ensure that security of that you take the responsibility. That is, if you are storing it, store it in an encrypted fashion. Don't make it available very easily. Like, don't put it on a let us say CD and leave it on your table. That kind of thing you should not do. So security should be taken care of. There are many colleges, chemistry labs, which may do say DNA kind of research. They are very high level of security requirements are required for that. So different departments, sociology department may do a research. Okay, many of that can be done without identification. You collect the identity, I mean the information from your students, but you de-identify, anonymize. Anonymization is permanently removing it. De-identification is like you do your answer papers. No, before correction you change the cover page so that the evaluator doesn't know whose this thing is that. So that is de-identification. You can do that. Then whatever purpose you want to use it, you can use the data. But ensure proper documentation is there, and after collecting, have security. Then after the research is over, think whether you should retain that data or destroy that data. Okay. Yeah, Rajeshri.
Good afternoon, sir.
Yeah.
Sir, I would like to ask 3 questions here. First, you say that it's like the human rights is having restrictions on the technology. And second thing is there is a problem with the public and private discourse, because till date we do not know what are the areas coming under public and what are the areas coming under private. So it is a completely confused state of affairs, not only regarding what is coming under privacy. Even we don't know what is coming under public, because we have a controversy related to technology and the marital law, Hindu Marriage Act. Third thing, sir, I would like to know, sir, when we are in colleges, hardly our authorities take the consent, because it is accepted that they have the right to take decision. They don't ask for consent, they themselves do it, sir. So, sir, I would like to tell you one more thing here. Joseph Stiglitz, after this W2 attack, said that everything, whatever is happening in the modern world, is manufactured consent. Like whatever we are saying, like it is like the human rights. Joseph Stiglitz and I'm just forgetting one American human rights activist. They say whatever human rights, whatever is our need, technology is providing something else. It is manufactured. Sir, I just would like to request you to give your highlights. The technology has restricted our rights.
Let's go one by one. Okay, you tell me the first question which you asked.
First question is, sir, you said that it is that human rights which has restricted
now, privacy is actually a human right concept. But now we are talking of an educational institution or a research institution or an IT company and say it is your responsibility to protect the human right of XYZ, which is translating the human right into the technology area. I told you why it is happening, because the court feels that you cannot protect privacy without protecting the personal information which is in data form. Okay, because nowadays data is not held only in paper, it is all in the information form. Therefore, it is making the IT companies liable for this. Your educational institutions are also IT companies in the sense that you are processing the information in electronic form. Okay, that is the translation which has happened. It is inevitable. We will face that. Okay. Now,
no, sir, my question is not that. My question is that whether it is the human rights which has restricted the technology or the technology has manufactured the rights.
No. Say, human rights is protection of privacy. Now, technology is processing the information. Now, where is the question of manufacturing? You may say that when a consent is asked, a person does not have time to go through the entire consent, he just keeps on clicking. Okay. So that is where most of the difficulties come. Indian law also makes a provision for something called a consent manager. I just skipped that slide fast, but the consent manager is an entity which can act as a trustee of the data principles and ensure that his rights are protected. In copyright law, you know that there is a copyright societies. You have heard of that? That is,
yes.
A copyright society tries to protect the copyright of the individual copyright people because they cannot be able to take litigation, etc. Similarly here, a consent manager is an organization which can give consent on behalf of data principals and also withdraw the consent. So this manufactured consent may be possible if you are talking of obtaining the consent from an illiterate person who is in a hurry to get some particular app installed or something like that. But when you have a informed consent manager, that consent manager can ensure that people will not be taken for a ride. Okay, this is what the law has provided. Now, beyond this, if some technology people like Google and others give a 10-page privacy policy, you are not able to understand that. That is a part of the practical issue. That is where specialists have to come in place and say that this privacy policy is acceptable, not acceptable. Now, WhatsApp privacy policy was rejected. Now it has gone to the court. We can decide whether it should be accepted or not. So, intervention of specialists may be required to ensure that the innocent people are not shortchanged with a privacy acceptance or a consent which they don't understand. Okay, in India, we also have a language issue. So if you have a privacy policy in English, how many people will understand it? So the need for a consent manager is very important. Secondly, Indian law calls this person who is processing as a data fiduciary. If some of you have heard of GDPR, which is the European law, it calls these people as a data controller. Why is that in India we call him as a data fiduciary? We treat him as a trustee. Say, when you make somebody a trustee, then even without the subject expressing what he wants, you are supposed to take care of his interest. Are you getting my point? So in India, the processor, the first processor who is the controller, is actually called a fiduciary, having a trustee kind of a responsibility on the data principle. So Manufacturing means he's going for breach of trust. I can put him into jail for breach of trust, which is the hallmark of the Indian law. See, in a data controller situation, I will say, take a technical stand. I asked you these questions. You said yes, yes, yes. Therefore, what I am doing is correct. But in a data fiduciary situation, that will not be acceptable. The court will take a view at that point of time. You ask these 10 questions. Do you think this person has understood that before he clicked a button called accept? Because after all, the accept button clicking is not a contract under Indian law. So you, as the receiver of the information, has got more responsibility to take care of the interest of that person. That is the beauty of Indian law. It will to some extent address the concern you said about manufactured consent. Then you said public and private law, private information. Whatever you said,
No, sir. My question is that even now, till date, we do not know what is coming under public sphere and what is coming under privacy. Because in privacy, first you spoke about Article 21 of the Constitution, but on 18th of July, Supreme Court said, no, it is not only about right to life, it is also right to speech and expression.
No, see, always freedom of speech and privacy will be in conflict. Okay, so if a conflict arises, the data fiduciary is expected to do what we call as a harm audit and decide. Okay, now the Information Technology Act already has defined what is personal information, what is sensitive personal information. That is personal information. What is not there is public information. Okay, so personal information in ITA 2000, password is a personal information, gender is the health information, financial information, sex orientation, that kind of a thing are defined there as a personal information. So there is a definition even now, even before PDPA comes. So there is no ambiguity there. Only thing is, in the PDPB, maybe password will no longer be considered. Some minor changes could be there. Political opinions is added in the PDPB. Caste is added as a sensitive personal information. So there will be some change, but there you are going to have a list of information parameters which makes an information personal, and what is not personal, by default it is non-personal. See, non-personal is not going to be defined. Only personal information is to be defined based on certain parameters which are listed even today in the bill in the definitions clause. If you go to the definitions, you know what is sensitive personal information. You also look at Information Technology Act section 79, the regulations. Okay, their personal information is defined, and 43A sensitive personal information is available. So there is a definition to distinguish information from personal, non-personal. PDPA says anything which is related to a person, that is living natural person, is considered personal. Some of which are defined in sensitive personal information. Other things, as I told you, a research paper or something like that, which you may be indirectly identifying a person, depending upon the context, it will be considered as personal. Okay.
Thank you, sir.
Yeah, if you have any more questions, information, requirement, you please send emails to me. You are welcome. You are welcome
Yes,
to
sir. Yes, sir. Thank you, sir.
question
Thank
me,
you, sir.
because I think we have already exceeded 5 minutes. Next speaker would be waiting, so I don't want to give a trouble to that person. Okay. Yeah.
Sir, can I ask one question?
You can. I have no objection.
Okay,
Yeah.
sir. Okay, sir. What will be your thought on the point that having considered that we will have a very stringent data protection law, there will be no breach of privacy, or there will be no leakage of data.
No,
How it will
having a
ensure?
law will not prevent the breach of privacy, but it will put a cost on negligence in protecting the personal information. Companies will have to invest more on technology, people's education and others to protect. Therefore, breach can be reduced. Okay, but just as crime cannot be 100% reduced just because we have got a 3 years imprisonment, 10 years imprisonment, data breach also cannot perhaps be 100% prevented. But companies will try to be putting in place in good faith, good security measures, making it more and more difficult for people to have a breach. If an organization can use proper pseudonymization, 80 to 90% of the risk can be brought down. Okay, so it's all a question of how they address it. Encryption, pseudonymization, de-identification, these 3-4 items if you use, then the data breach, even if it happens, if it is an encrypted information, no problem. If it is a de-identified information, then again there is no problem. Problem will come when you are identified your say credit card data, if it is available with your name and address, then there is a problem. If it's a de-identified information where card number is different, your name is different, then it is not going to hurt you. So that is where we are leading to.
Thank you.